Will the Washington County Services Committee meeting please come to order? Good evening, ladies and gentlemen. Tonight, the prayer and the pledge will be led by Justice Massengale. Justice Massengale, if you would please.
Yeah, let's bow our heads and thank God for the many gifts that we all enjoy, for this beautiful country that we live in and this beautiful part of the country that we live in. And let's also ask for the wisdom to serve the citizens of Washington County to the best of our ability. Amen.
Amen.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Justice Massengale. Do I have a motion to adopt the agenda? I have a motion by Justice Lemming, a second by Justice Ricker to adopt the agenda. All in favor? Aye. All opposed? The agenda has been adopted. Next on it is Chairman's report. I'm glad everybody's here, and that's the end of the report for this month. Moving on, you're welcome. You're moving on to the juvenile detention report. We have Director Tinsley. Good evening, Director Tinsley. Are you on?
Good evening, Madam Chair.
Yes, you are.
Yes, ma'am. Good evening, Madam Chair, and good evening to the County Service Committee members. I'd like to share our Juvenile Detention Center monthly report for March 2026. This report covers 24 days of data. In March, we had 21 intakes, and the average length of stay was about 14.91 days. Our average daily population came out to just over 12.38 residents. The most common charge for intakes was assault third misdemeanor at 10 cases. Of the 21 intakes from Washington and Madison counties, 10 intakes were from Division 8 and 10 intakes were from Division 3, and 1 intake was from Madison County. We also had 4 transports during the month of March. All 4 transports were handled by the Washington County Juvenile Detention Center. And that concludes the March 2026 report. Are there any questions that I can answer at this time? Thank you, sir.
I have Justice Dennis.
Thank you, Madam Chair. It's a different kind of a question, just because something had came up.
Sure.
And they were looking for volunteers to do some work, and part of getting a grant was that they had to have volunteer hours to offset some of the, some of the grant. Otherwise, you have to have 20% and your work counts. And I know that the FFA does it quite often, that kind of work. I just wondered if, does your group ever do any outside work?
Well, when I was a probation officer, Justice Dennis, we did do some outside work with the kids. Mainly the food bank in Springdale. We would go up there in the summertime and help, move perishables, frozen meats, and stuff of that nature. So we used to do a lot of volunteer work, gardening as well. And so
Well, I just had that thought whenever I was trying to help this lady get a grant, and
Yes,
part
sir.
of it was volunteer hours.
Yes, sir.
They had to have so many.
Absolutely, yeah. We spent a lot of summers out there planting watermelons and vegetables and things. When I forgot the guy's name that used to be over the Department of Veteran Affairs, but when he was here back in like 2017, 18, we did a lot of work with him.
Okay.
Yes, sir.
All right. Well, thank you.
Absolutely.
Are there any other questions for Director Tinsley? I have Justice Koger.
Thank you, Madam Chair.
One moment, please.
Thank you, Madam Chair. Mr. Tinsley, I just wanted to thank you for that wonderful report that you sent us last week, and I guess that's what we're going to hear about tonight. But if you put that together, that's amazing.
Well, I don't have any credit for that. We're gonna have to thank Ms. Shelley Klingen and her department for that remarkable report. I was blown away when I first saw it, and I was so eager to send it to you all. And we were in my office last, I think it was Tuesday, we sent it out, and we're just sitting there, and we just, we chatted for about a good hour and a half about all the hard work she has done over the 21 years of being a part of the juvenile 22, 23. In May, it'll be about 22, 23 years. And so the SWIP program, I don't want to just go in depth to it because I'd rather her explain it. But, it was a pilot program, and, it's just taken off. And we're very proud of the work and the data that she has compiled over the past 2 years. So be ready to be blown away.
Great, thank you.
Yes, ma'am.
Very impressive. Are there any other questions for Director Tinsley? Thank you, sir.
Yes, ma'am. Thank you, Madam Chair.
Next, we have the Sheriff's Office report from Sheriff Cantrell. Good evening, sir. See, got C-20.
Good evening, Madam Chair. You've got your report in your packet, and you can see that our calls for service for our enforcement division is up again this month, so it looks like it's running about 10% ahead of this period last year. But at this point, we're able to keep up. We've got almost all of our slots filled on the enforcement side, so we've got the deputies on staff to be able to handle those increase in calls. Our detention intakes, we're up a little bit over a year ago. We're not sending as many to prison, and that reflects in our average daily population of our state prisoners. So that's where we're hurting. It takes about 6 months on average to get somebody to the Department of Corrections. A little quicker for the community corrections, which are the nonviolent offenders that have a shorter term to serve, but to get to the Arkansas Department of Corrections is about a 6-month wait currently. So that number just, the stream keeps flowing, but it's not able to get on down to the Department of Corrections. I guess they just don't have any beds either. So that's something that we're dealing with. Pretrial population is down, and we're again thankful for our circuit judges for working hard to help keep the detainees moving through the court system. I know J.P. Koger usually asks, and I have some of these. I may not have all your answers, but we currently today have 34 309 inmates in the county jail, 16 males and 18 females on 309s. We have 99 females for our female population today. Federal prisoners are up a little bit. We've got a total of 95 federal prisoners, but they just had a grand jury convened and some indictments came down, but they've also sentenced several, so they told us Friday that they'll be moving several out to their facility over in Cimarron, Oklahoma, the federal. So we expect to see that number turn down just a little bit. 146 currently sleeping on the floor. None of those are females, all males that are on the floor. And any other questions? I may not have answered them all, J.P. Koger, but certainly I'm available if I didn't.
J.P. Koger.
Thank you, Madam Chair. Sheriff Cantrell, you did answer most things.
Oh, okay.
I just have a couple more.
Yes, ma'am.
If you mentioned, I didn't hear, and what about COVID, or do you have any COVID?
I've got 3 cases, 3 positive cases currently.
And you have, so how many in quarantine?
Just the 3 right now.
Just 3, okay.
Yep.
You mentioned 95 federal prisoners. What about immigration? How many?
Immigration, of those 95, let me look here, immigration, 6 of those are immigration.
Okay, and you said pretrial was down, but I didn't hear a number. Could I have
Yes, today's number for our pretrial is 352.
Well, that is down. That's
Yeah, yeah.
a lot better.
Yes.
Okay, and if you haven't updated us recently about staffing for the enforcement and for the detention center, if you could do that.
Yes, ma'am. Our enforcement section, our patrol CID, we're only down 2 people in that division. We're down 2 people in our communications or our dispatch section, and still have about 25 openings in detention, but we've got some in the pipe that are in background, so got a few coming on board that, or we think will be on board. Have probably, see, I counted them this morning at the table, there were 6, we call them black shirts. When they first start, they're wearing black shirts. So we've got 6 of those that are in training, and so they'll be out in about 6 weeks. They'll be completed with that and ready to take on the role of detention officer back in the housing units.
Okay, and my last question for you is, could you give us an update, like when we had a few, last month or the month before, when Mr. Lance Johnson came and talked about different sections like that had been turned over to the sheriff? Have all the sections of the new expansion been turned over to you?
No, the housing unit, the 88-bed housing unit is still under construction, but we've got the kitchen that's been turned over. We've got the warehouse is turned over. The medical suite that we expanded is turned over to us. In fact, we just got our certificate of occupancy on Friday from the fire alarm people. They came in and did the final test on the fire alarm, so we got that able to occupy that medical suite now. And then our intake area is complete, and we've got that certificate of occupancy. So it's all the in the existing part of the jail, that's all done. It's the new construction that's going on out on the north side of the complex is the only thing left that they're working on.
Okay, and that new construction, which they're still working on, what was the final decision on heating and cooling for that building? There was some discussion it was only gonna be heating, and then there was a discussion about having heating and cooling.
The unfinished portion, or the portion, the north side of it that won't be occupied, I think they have determined now that there is no water on that side of the building currently. They've got a cutoff valve, so there'll be no water over there, so there'll be no heating or cooling initially. And so if we want to add that at some point, then we'll have to come before the court and ask for.
That was my
appropriation.
question.
Yeah. Yes, yeah. But
Okay.
I think in the current plans, there's no HVAC going in currently into that unfinished, unused portion, because there's nothing that we need to keep from freezing.
Can you think of anything else like that you might be having to plan to come to the court for in the future?
Well, nothing, you know, I think that everything else that we factored into this budget, you know, we won't take much more cleaning supplies. It's a few more square feet to clean, but we factored that into this 2026 budget for additional cleaning supplies and mop buckets and things that we'll need for those additional housing units. But nothing big that we're aware of right now that we'll
Okay.
have to come before the court for.
Well, thank you, and thank you for that good report.
Yes, ma'am.
Thank you. Sheriff, you did mention the medical occupancy of that facility. What is the occupancy?
Well, it went from 4 beds to 8 beds. So we've got 8 beds in our medical suite. Now it'll have its own dedicated shower area instead of having to move somebody to the booking area for a shower. And it'll have its own dedicated exercise yard. So we'll be able to utilize that for those folks that are in medical holding for their hour of outside exercise or outdoor activities that they're not guaranteed, but that they're allowed, weather permitting. So that'll free up having to utilize a different exercise yard or having to take them up into the booking area. So it's going to be very
lot more
beneficial to our folks that work there in the medical department.
That's great. Are there any other questions for Sheriff Cantrell? Seeing none, thank you, sir.
Thank you.
Number 7 on the agenda, we have the Social Work Intervention Program Annual Report. Go ahead, come on up. Is it Cleanham or Clean? Okay. Good evening. I know. Hey, I've got Eggie, so would you push your button there? Thank you, and I'll key you on.
Thank you.
Thank you.
Good evening. My name is Shelley Klingen. I work with Washington County JDC in the Social Work Intervention Program. I've worked in this program for 22 years in May of this year. I've been through 4 county judges and 3 JDC directors, so it's been a minute. The program itself offers clinical social work services to youth at the detention center and a few non-detained youth. We're starting to see a bigger need to serve non-detained kiddos. The Arkansas Juvenile Detention Standards require that JDCs meet the mental health needs of youth, and so the social work intervention program helps to meet that need. We also see that mental health, trauma, and neurodevelopmental disorders are disproportionately prevalent in juvenile justice, and so we work to address those disparities. For 2024 and 2025, we provided roughly 5,500 services to about 75% of the youth detained at the detention center. We also work to improve the juvenile justice system at the meso and macro levels. For example, we entered into some collaborative partnerships with UAMS to bring training to juvenile justice stakeholders in Washington County, as well as to bring screening tools for TBI, which is traumatic brain injury. And so that is also disproportionate in juvenile justice. We see the national research says that about 40% of youth screen positive for a traumatic brain injury, and that is exactly what our numbers are showing. We also have been able to write best practice for NPJS, that's the National Partnership for Juvenile Services, as well as advocating for neurodevelopmental service development evaluations in the state of Arkansas. Michaela Wallace is my colleague, and I both serve on the executive board for the Arkansas Juvenile Detention Association, and this year we also had the opportunity to facilitate writing of juvenile standards, which will be presented to the legislature this May. And so we're working micro with the families in Washington County, as well as at the meso and macro levels. So the question I'm sure that's on everybody's mind is it effective? And what we have been able to show, we did an annual report for 2024 and 2025, just our service statistics. That is that 23-page report. We're not going to go by that line by line. You do have a digital copy in your agenda, as well as if you need a physical copy, I have a copy with me. So I gave you the executive summary. That's the short version of everything that I'm telling you. So we were able to run some statistical tests to see if we're effective. What we found is that for 2024 and 2025, the recidivism rate for Washington County JDC within the same service year is about 25%. That means about 1 in 4 come back to JDC. So then we ran those numbers to see if they received clinical services with the SWIP program, Social Work Intervention Program, if that changed the outcome. And it did by about 11 percentage points, which for 2025, our recidivism was about 14%. So we did a 2-proportion Z-test to see if it was significant or not, and the results were it was clinically significant, or statistically significant, excuse me, that we dropped the recidivism rate. So we are able to prove scientifically that the social work program is an evidence-based program. And so it's super exciting. We're super excited. We've been providing these services for 20 years. We have those same kind of outcomes, but now we can show that it is effective. And so we're wanting to be identified as a model program. I've sent to OJJDP for their model program status, as well as the National Partnership for Juvenile Services has asked me to speak at a symposium nationally in the fall. Fiscally, it's not going to be feasible for me to do that, but it's still an honor that we've received national recognition on our outcomes. So that's super exciting as well. There's so much more I can tell you and talk about. I gave you a 23-page report with the outcomes as well as the annual report, but I'm trying to honor your time, and so I'll tell you as much or little as you'd like to know. Are there any questions?
I do. Right off
Okay.
the bat, your traumatic brain injuries.
Uh-huh.
How many did you say came in?
So we were able to screen, so this was our pilot year. 2025 was our pilot year
Okay.
screening for that. We were able to screen 92 because we have to get separate consent from the parent or guardian. Some parents don't want their kids screened, but we were able to do 92 screenings and 43% tested positive for a potential traumatic brain injury. Now you have to remember, screening is not diagnostic. We're just saying, hey, you've had some potential impact and you're showing some symptoms of it, and so it would be.
That was what, if you could repeat that, how do you identify a child that might have potential brain injury?
So the initial screening is just a screening, like we can give it to everybody in this room. It's just an initial screening. Have you had some experiences that would have led to a traumatic brain injury? Like have you had a car accident, falls, football injuries, different things. And so you can say yes to that, but then we look at, okay, are there symptoms associated with that? Problems with memory, impulsivity, and different things like that. And that's where a good assessment comes into play because if they've had that pre-injury, then it's likely not the cause of it. But if, those symptoms onset later, then you're going to want to get that evaluated.
That's great. I have Justice Bruns. One moment, please.
Hey, thanks for your report. This is absolutely wonderful.
Thank you.
I have a degree in social work, so I'm very interested in it. But
Yes.
my question is, when you talk about recidivism rates, do you see like one person come in like for 3-4 months at a time, or is that recidivism usually once and then you don't see him again for a while? Or
Okay, so yes, to both ways. So what we see everything. So when we talk about mental health, trauma, neurodevelopmental disabilities, I cannot tell you how many we identify as having autism, who's never been diagnosed before or identified before. We've identified youth in their adolescence who have intellectual disabilities. Like I had a kiddo whose full-scale IQ was 66, and nobody had recognized that before. And so it depends on the youth, The way that research is, 75% or more have diagnosable things, mental illness, neurodevelopmental trauma, all of the things. But, which is disproportionate, it's like 3 to 5 times the general population. If you have a youth who doesn't have any of those things, we may see them once because they learn from their mistakes. If they have more of the complex needs going on, they are our repeat offenders. Oftentimes, it's going to be the ones who have mental health issues along with the neurodevelopmental pieces. Those are our hardest cases because the mental health system pushes them to the neurodevelopmental system and vice versa. And nobody's treating whole person functioning. And so we have to advocate for the right services with the insurance, their pass, with all the providers, because if you send a kiddo that has a neurodevelopmental to an acute hospital, they're getting kicked out and getting new charges because they're not understanding how they're functioning. And so there's all of these things that we're navigating and barriers that we're trying to help the youth and the families to make sure they're getting the right services that they need.
wow, you know your stuff. You're pretty good.
Thank you.
You want to continue just sharing, or is that?
Well,
Pretty much.
I was told to be brief, but I'm happy to continue sharing. I teach at the university, and so I can talk to you the rest of the evening if you have time. We can just start now and go through all the pieces. What else would you like to know about as far as day-to-day services at JDC? So a youth comes in, we go to work We do initial screenings. The staff do a safety screening. We do a MAZE screening for mental health in the last few months. We do those OBIS screenings if we have the consent. We're finding out who, if they're already in services, are they on meds? Can we continue the meds or not? And then filling those system gaps to make sure that just their general day-to-day mental health needs are met. And then we work really closely with the court system. Judge Warren's here, as well as Division III Court. Those assessments that we do are court-ordered, and they are specific to our system, because they're unique in that we do a diagnostic mental health, gathering all the records, connecting with collateral resources, figuring out what has been tried so far, what has been done, what has worked, what has not worked. Diagnosis tends to be progressive, but then we're also evaluating the system. What is feasible for this family? What kind of insurance do they have? Can they access the level of services that we're recommending? Because it does no good to recommend them if they cannot navigate them. And then we are able to help them with case management and navigating. So some of the services that we've been providing for non-detained kiddos are just helping them follow the recommendations of our assessments. And our assessments can take up to 20 hours. That's why it's so great to not be involved with managed care, because we can put as much or little time into each report as we need to in that assessment. And so then we go to work trying to help navigate what we've recommended. This level of care, that level of care, this type of treatment, and so forth. And so it's a full service spectrum, One of the things that we have been super careful about is making sure that JDC is not seen as a treatment program. We are not treatment. We've based it on an assessment center model because that's evidence-based practice. Research shows that youth do better when their juvenile justice is administered locally in the community, and so that's our goal. And so we are assessment, and we'll assess them, but then we send them back to the community to get the services that are being recommended.
Could you name some of those community partners that you're able to send them back to that will help the families?
Yeah, of course. So we have different levels of care. Of course, you have your acute hospitalization for the immediate crisis. Within the community, we also have our outpatient providers. Some, specialize in trauma or substance use, like CSI. Of course, we have our community mental health center, and there's some various private practices that take Medicaid as well. Those are few and far between, but we do have a list. And then we also, there's the intensive family programs. And so a lot of times we're making that recommendation where they're going to the home and providing skills for the families. And there's the youth advocate program. We have our list. There's about 4 different providers that do that for us, or for the county. And then there's substance use treatment. Mostly CSI does that on the outpatient level. There's not a rehab for adolescents in the state of Arkansas, and so that has been one gap in our system. One of the things that we recommend often is neurodevelopmental evaluations, and those are super hard to come by. Schmeeding is, today I found out, 16 months waiting list. So we are constantly trying to figure out where can we get these evaluations. There was a luncheon last Friday where it was autism providers coming together, and so we were able to gather some information about, some new providers potentially for neurodevelopmental evaluations, just to get the initial autism evaluation. Our schools aren't doing it. What they do with the special education is they serve the behaviors, is what they've told us. And so they won't diagnose autism, but they will serve the behaviors that they see from autism. And so to access any kind of state resources, we have to actually get them diagnosed. And so we have to try to get that neurodevelopmental evaluation done. And the screening tools. So in my practice, they teach you in social work to evaluate your own practice. And so, I start seeing, am I biased in my lens? Because I'm seeing all these kids who I think have a neurodevelopmental, issue. Sometimes bipolar, we see that a lot. And so I started evaluating my own practice, and we started using a lot of different screening tools. And so that brings a measure of objectivity to the diagnostic process, because I'm like, how are they going through all of these systems and being failed? They've been through the educational system, a lot of times the mental health system, all of these different systems, they're PCPs, and they get to us and we're like, I think they have autism. And so we have started using screening tools that help us to determine that. The autism screener that I use is 99.5% accurate in predicting autism and differentiating it from any other mental health diagnosis or neurodevelopmental. And so whenever we get the kids in and we're screening them for autism, and the parents will say, well, I've long thought they had it, but can't get anybody to test or to look at it. And so we're able to administer that screening, and I can say definitively, yes, let's invest some resources in getting them assessed. Because it's a long, lengthy, costly process, I don't want to just be sending everybody for neurodevelopmental evaluations. And so we're able to say, yes, definitively, let's send this youth. I have one youth, I can tell you so many stories, but I have one youth who, he was 10 years old when he first came to JDC. And we assessed him, I assessed him, and I said, yeah, I think he's on the autism spectrum. He scored on the screening as being on the autism spectrum. He came in, so we had a PASS meeting right away. The PASS, if you don't know, is in the Arkansas Medicaid system. There's 4 passes, and they do the managed care for Medicaid. So every kiddo who has a pass is supposed to have a care coordinator who manages their cases. So I call a pass meeting, and I'm like, I think this youth has autism and needs a neurodevelopmental. And they tell me, okay, we'll get that done. Well, so they were supposed to be working on that. So for the next 2 years, he was coming in and out of JDC, you know, being... he's on the spectrum. He also has mental health diagnoses, several. And so, you know, where every time he comes in, we're like, he still needs the neurodevelopmental. And so this last time he came in, and we called another PASS meeting, got with the PASS, and I said, what happened? He was supposed to get this 2 years ago. He's 12 now. And Mom said that the PASS, there wasn't anybody in network for him to get the evaluation. And so I went all the way to Leslie Sebrin, the head of DHS, and we got him assessed, and he's on the autism spectrum, and that just came out like 2 weeks ago. We figured this out for him. He's 12, and so now our next steps is to get him some state services, CES waiver, and you know, the right supports in school for autism, and hopefully keep him out of the justice system as he turns 13, 14, 15, and so forth.
Well, that was my question. What was he doing at 10 years old that warranted him going to JDC?
Well, I'm trying to remember. Mostly things related to autism. Meltdowns, not listening, you know, that sort of thing. But it's not, what happens in our system is that behaviors are defined as willful every time, and rather than assessing what's going on. Like, if someone kicks a teacher, we don't know. I mean, the assumption is, you know, that they've done wrong. I mean, they have done wrong. It's not okay to kick a teacher. I'm not advocating for that. However, you know, is it during an autism meltdown when they're not in effective control? Is it, you know, somebody who has bipolar not effectively managing their mental health and they're in a bipolar rage? Is it that they have trauma and they have been triggered and they're in fight mode of trauma? Or are they just a little turkey? You know, like, what is going on? We need to assess what's going on. But the law doesn't give that discretion. You know, you've done wrong, you're going to jail. And so that's where the social work program comes in, and we're able to assess those mitigating factors, those things behind it that's driving that behavior. And so, and then help navigate the services in the community to address what's going on. And so, so I don't recall exactly for him, but it was something in that vein. Maybe he hit his mom, something like that. But they handled it in a Finn's case. They didn't actually put him in the delinquency side. Okay. But, you know, it's not evidence-based treatment to put youth who have Finn status offenders in detention. But, you know, that's one measure that can happen.
Do I have any other questions? Wow. Terrific work that you're doing.
Thank you.
Congratulations. I mean,
Thank
you're
you.
to be commended.
If any of you want more information or want to reach out or want to come visit with us at the social work program, you're more than welcome. Yeah, it's an open invitation, and I'm really willing to answer any and all questions and to educate. It's so much. The 23-page report just barely captures it. It doesn't even start to encompass all of the things.
Oh, my goodness. That's
Okay.
fantastic. Thank you so much.
Thank you. Thank you.
Next on the agenda, we have item number 8, the Juvenile Justice System by Judge Warren. Thank you so much for being here this evening, Judge Warren. And I think this is perfect timing. We've been going back and forth on trying to get you here. Are you on?
It's green, now it's red.
Okay.
She's got it. Well, turned it on.
Okay, turn it on again. Just press it,
Leave it.
and then I'll just leave it.
Now it's red.
But I think now's the perfect time. Good evening.
Good evening, and thank you so much for inviting me to speak tonight. I think this is going to be great. You are getting a very full plate of juvenile court and juvenile services this evening. So you first heard from Director Chris Tinsley, who told you about what happens at the Juvenile Detention Center. And his role is to take care of the juveniles while they are detained. They'll get their education there, they'll get their mental health services, educational services if they are detained for a lengthy period of time at JDC. That's his part of the picture. Shelley Klingon and her team are so amazing. You should be super proud that Washington County has this program. When I go to judges' meetings and talk about services that are available across the state, no one has a system that compares to this. It was well worth the money that we spend on it, and I can tell you that I rely on the SWIP assessments that we get every time we have juvenile court. The reports are always comprehensive, helpful, concrete, so that we can figure out what is contributing to that juvenile's behavior that is unacceptable, and we can start putting services in place to get them back on track. And that, of course, is what we do as the juvenile system. So the reason I wanted to speak to you all is because I listened to one of your meetings several months ago, and there were lots of questions raised about who was in JDC, why were they there, why were they there so long, why were they not there longer, all those kinds of questions. JDC and the folks at JDC do not make that determination. That is the role of the juvenile court. And so I wanted to come help you understand how the juvenile court works in conjunction with JDC and the SWIP assessment and other stakeholders in the system to deal with our young people. So I have a slideshow here that I'm going to tell you. First of all, and this may be old news to you, so I don't mean to tell you something you don't already know, but I do know that there are many people who don't really understand the court structure in Arkansas. So I'm just going to start out big picture and take us down, and I won't belabor the point here. The highest court in Arkansas is the Arkansas Supreme Court. Below that, you have the Arkansas Court of Appeals. And below that, you have the circuit courts. So the circuit courts are basically your trial courts in Arkansas. There are 5 subject matters that circuit courts deal with. Those are criminal cases, domestic relations, that includes your paternity, child custody, divorce. You have civil cases, those are your contract disputes, your other kinds of contract disputes. Then you have probate. Those are guardianships, adoptions, and end-of-life estate administration matters. And then you have juvenile. All right, so juvenile cases are one subject matter that circuit courts handle. And so, and then below that you have state district courts, and those handle traffic cases, minor criminal cases, civil and small claims cases. So I am a circuit judge and handle juvenile cases as well as some other things. And Division 3, so I'm Division 8. In Washington County, we have 8 divisions, 8 judges. So each division, we all divvy up those different subject matters. And so the two divisions that handle juvenile cases are Division 3 and Division 8. So Judge Dawn Egan is the judge in Division 3, and I'm the judge in Division 8, and we split the juvenile docket. So each of us handles 50% of each of the different kinds of cases. And the different kinds of juvenile cases that you have are basically three kinds. The first kind of case that we have are the dependency neglect cases. And those cases, a dependency neglect juvenile is a juvenile who is at risk of serious harm as a result of neglect or abuse. In the dependency neglect cases, the juvenile is a victim. The second kind of case are the family in need of services cases. A family in need of services is any family whose juvenile is habitually absent from school, habitually disobedient, absent from home without justification, in other words, a runaway. The juvenile behaviors are problematic, but they're not illegal. The third kind is the delinquency case, and a delinquent juvenile is one who has committed an act that if that person had been an adult, it would be a crime. So it's a juvenile who has acted contrary to a provision of the criminal code in Arkansas. So our mission, I'm going to talk to you mostly about the two cases, the FINs and delinquencies, because that's what feeds the Juvenile Detention Center. So our mission in the juvenile court is to protect public safety by holding adults and youth who come before the court accountable for their actions, and then provide them with education and resources so that they can do better. So our main purpose in juvenile court is rehabilitation. And the main difference between the juvenile system and the adult criminal system is that our primary purpose is rehabilitation. We are going to try to provide services to youth while they are still youth so they do not end up in the criminal justice system. That's what we're trying for. Our core values are responsibility, that people are responsible for their actions, accountable, that they take responsibility for what they have and have not done, and respect. Respect for each other, respect for the rule of law, respect for authority. So, who gets sent to JDC? Well, the dependency neglect kids don't get sent to JDC. They're victims. They may act like little turkeys, but they don't go to JDC because of the behaviors. They go if they are determined to be either FINs or delinquent. So we may have dual system youth. So we may have a youth in foster care who also has committed an act that would be a crime if he or she were an adult, but they don't go to JDC through a dependency neglect case. So the ones we do see are through FINs if they are found in contempt. Because remember, I told you, FINs cases, they haven't done anything illegal. They're not going to jail, but they are given rules to follow. They are given orders to follow. They are expected to change their behavior. So we see kids coming into FINs who maybe have missed 73, 96, 102 days of school. We're not talking about kids who have, been a little bit out of line. These kids are missing a significant portion of their school year, and the problem is that they are not learning what we as a community need them to know so that they can go out there and be productive citizens and hold a job and pay taxes and help us pay for roads and bridges and police. So we need them to be educated. We need them to be guiding enough that they can show up and do what they're supposed to do, because that's going to be our future workforce. So if they're not following the rules of their case in the FINs, they're placed under terms of supervision, and if they're not following that, the FINs officer, the supervising officer, has lots of sanctions they can impose. Community service, an ankle monitor, essays, going to online classes to do different things, lots of sanctions. But if the youth does not change their course of action, then the supervising officer might ask the prosecutor to file a motion for contempt. So let me tell you, if there is a kid who ends up in JDC for contempt out of a FINs case, they have earned their way there. They have been given plenty of opportunity to change their behavior, and we have ruled out that the reason that they are acting contrary to the rules, we've ruled out that they are doing that because they are suffering from a mental health condition, or that they are suffering from some other kind of impediment, that there is no barrier to them that they are able to do what we have ordered them to do, and they are making a willful choice not to do it, and that will earn them to JDC. So you don't see very many kids at JDC who are FINs. The ones I have held, I put a kid in there in contempt. He was, 17, almost 18, and all he needed to do was to get his GED. He had been putting it off and putting it off and putting it off. I sent him to JDC for 20 days and he got it done. I mean, he just needed to go get it done. So anyway, that's how FIN's cases will end up there. Now, delinquencies. This is what happens with delinquencies. They'll either end up there through an initial arrest, they'll be arrested on a warrant, or they'll be remanded at a hearing. They'll come before a hearing, and the evidence is that they're just not doing what they're supposed to do. They're in violation of terms, and off they go to JDC. So I was telling you that a FIN's case, what happens with a FIN's case is you get an affidavit, usually from the school, saying that the youth has done something that is concerning, usually that they are habitually truant from school. We have an adjudication hearing. We see if the evidence matches up to the allegations. If so, then largely the youth is placed under supervision for a period of some months, maybe 6 or 9 months. And then we offer them services to try to get them back on track. And then as I was saying, if they don't do that, there's a petition for citation of contempt. And then if they are determined to be in contempt, then they go to JDC. Delinquencies. So in delinquencies, oftentimes the first contact between the youth and the court is really through an arrest with a law enforcement officer. So then what happens when a law enforcement officer arrests a juvenile, they arrest the juvenile and then they call an on-call juvenile officer. And that's going to be a juvenile officer hired by the juvenile court that's going to either be from Division 3 or Division 8. We have an on-call phone. We swap it every week. So there's either an officer from Division 3 or Division 8 that answers that phone 24/7. When the law enforcement officer calls the juvenile officer, what they do is they determine whether or not they're going to detain that youth. And in order to do that, they use two standardized forms. We start off with what we call the RAI, the Risk Assessment Instrument. And the Risk Assessment Instrument is a tool that's used to determine specifically whether or not the youth should be detained. So it looks at the current event's severity, any prior history, failure to appear in a previous case, any aggravating circumstances that contributed. So, the goal is to make sure that our decisions across youth are made consistently, fairly, and are data-driven, and are not driven by our hidden biases and might make a decision based on unintentional bias, based on ethnicity or economic status, or the fact that maybe we know their daddy and we know he was, not a good character. So we try to make sure that we're making decisions based on objective facts. So that we ask a bunch of different questions of the law enforcement officer who's there at the scene, and then based on that, there's a score. And so the scoring, 15 is a magic number. If you're under 15, you're not detained. If it's close to 15, then they go on and use this other assessment called the OYAS, the Ohio Youth Assessment System. And these are assessments that are used all over the state. So this is how juvenile courts operate. The law enforcement officer calls the juvenile officer on call, and you make these determinations. So this one, if you're at a borderline level, then you might go to this next assessment. You look at prior offenses, when this youth had their first contact with the juvenile justice system, family law enforcement history, what parental supervision you might have. You might have a parent who's not available. And so that tool is also used. So the juvenile officer on call makes a decision about whether or not that youth is either going to be cited or detained. So why do juveniles end up in JDC? You heard from Director Tinsley earlier that one of the most prevalent charges was aggravated battery, third, fights over cell phones. The teenager has a cell phone. The parent says, "Give me your phone." The kid doesn't give up the phone. They get into a fight. The kid hits the parent, we're off to the races. Police are called, kid goes to jail. Siblings have a fight. So when you hear aggravated battery, it might be that a youth has been involved in some altercation with peers or other people out in the community and acted violently. But it's much more likely that they have had some kind of a violent dynamic in the home. And quite frankly, it's a lot easier to arrest the kid than the parent. And so we end up with a lot of kids in JDC because they've had some sort of family violence in the home and they end up in JDC. Another instance is where they don't have a parent. We can't find a parent. When they're arrested, there is no parent available. We find this sometimes with our, either the parents are out of state or they're working, we can't find them. The youth won't give up their phone number or name, or they might not want to reveal who their parent is for some kind of immigration reason or something else. If we don't have a legal custodian to release the youth to, then they're detained. Another one is a gun. That is a automatic go to jail, do not pass go, do not collect $200. If you are arrested for possession of a gun or use of a gun, you're going to JDC. We'll sort out the reasons later, but if you have a gun, you're going to JDC. If there's a warrant, if you've been on probation and the court has determined that there is good probable cause that you violated the probation in a way that puts the public safety at risk, then there's a warrant and then you're going to detention until you can go in front of the judge and answer. And then runaways. If you have been reported as a runaway and you're picked up, you're going to go to JDC until we can figure out where you're going to go next. So if we have the decision that there's going to be a citation, so if the decision is not to detain, then they're given a date to show up at court. And that's going to be for a meeting with the juvenile officer. And between the time that the youth is arrested and the time they're supposed to show up at court, then the juvenile officer sends the assessments that we've done to the prosecutor. The prosecutor decides whether or not they're going to file a formal delinquency petition or not. So if they're not going to file a formal petition, then the youth either gets a warn and dismiss, which says don't do that again, shoplifting or possession of a controlled substance, maybe, first offense, if it's marijuana, say, don't do that again, off you go. But, or they might do a diversion. And so a diversion might be a little bit more serious, but we still don't want to actually file formal charges. So the youth and parents voluntarily say that they're going to go through some services, they're going to stay out of trouble, and if they stay out of trouble for a certain amount of time, then the prosecutor doesn't file charges and off they go. We really are trying to have the lightest touch possible with these youth because remember, first and foremost, they're youth, they're children. They're not criminals, they're youth. And so a lot of times you have to make that determination about whether they're making a rash, impulsive decision that ends up really badly because they're teenagers and their frontal lobe hasn't completely developed yet, or whether they actually have criminogenic thinking, whether or not they really are steeped in the criminal culture. And so you have to sort out the different kinds. If they are detained, then they're taken to JDC. And they have to go in front of a judge as soon as possible, but no later than 72 hours after they're detained. At that detention hearing, the court makes two decisions. Number one, was there probable cause for their arrest? And number two, whether or not they can be released. And that release decision is based on statutory factors. We have 8 factors that we have to consider about whether or not we can release the juvenile. And the question is there a threat to public safety, and will they show up for their next court hearing? And so you have to determine whether you have an adult caretaker who can appropriately supervise, whether or not there's been a history of this kid not showing up before. And we use a lot of ankle monitors because there's a whole lot of kids that we let out of JDC, but we put them on house arrest. So they're not at liberty. They're not free to go anywhere they want. House arrest means at home, at school, or with a parent. And we have an ankle monitor that tracks them no matter where they go, so we know exactly where they are. So if we have responsible parents who we think can actually supervise them, a lot of times we'll release them. Usually at the detention hearing, that's when we order the SWIP assessment. A lot of times we'll get that SWIP assessment when we come back for our next hearing, and it will really help guide what kinds of services we can place, what kind of things we can do with them. So then they come back for their arraignment. We follow the criminal procedure. So the arraignment, they are read the delinquency petition if they wish. They enter an initial response. We again discuss whether or not we can release. And then at the adjudication, if the allegations are met by the evidence, then we go into disposition. And they can be sentenced to JDC up to 90 days, but typically any JDC time is suspended on condition that they follow the terms of their probation. And then what we really strive for, there's the SWIP, which I love. I'm not going to go too much into that because you just heard Ms. Klingon talk all about it. But when we do the disposition process, that's when we're trying to figure out, typically we'll put them under probation for a period of time, and that's when we start to offer services. So that's when we're gonna, if they've been adjudicated delinquent for possession of a controlled substance, we get them for a drug and alcohol assessment and get them some substance abuse treatment, et cetera. So all that to say that it is the court that decides when a juvenile will be detained or not, and then how long that will last. And we work pretty hard to keep kids out of detention for a number of different reasons. And so part of which is if a kid spends too much time in detention, it'll be normalized for him. It's scary to think about, and it's uncomfortable when you first get there, but if you're there too long, you get used to it, and then it's no big deal, and we want it to be a big deal. We want it to be a really big deal when you go to JDC. So we just got our annual report done. Last year, we had 227 delinquency cases filed, in 2024, excuse me. In 2025, that number was down to 197, which is consistent with statewide figures which say delinquency cases are going down. And that's not necessarily because we don't have youth who are acting inappropriately, but we are trying very hard to work on the front end through diversions or through withdrawals, with withholdings, excuse me. On a withholding, the youth will come in, admit to the action that they have taken that they should not have taken, and then we just withhold an actual adjudication. They work services and show that they can be good citizens, and then if they are successful at doing that for some period of months, then the prosecutor will dismiss the petition and it will go away. So in 2025, of those petitions that we had filed, almost half were either null prossed or dismissed. We were able to provide services and the youth didn't have ongoing engagement. So that's kind of how that works. My main purpose, like I said, was to try to help you understand the difference between what JDC does, what the court does, and how law enforcement works in conjunction with the juvenile court. And so that's basically what I have for you tonight. And if you have any questions, I'm happy to answer those.
I do. Do we still have the diversion program?
Well, we have several different diversion programs. There's a teen court that is operated largely through the Division III, and so through teen court, that is a diversion program. There's no official involvement of the court. I don't even know that they've gone through it, so I don't hear information about whether they've been through a diversion program. But that is operated by peers. They go in front of a jury of their peers. The jury tells them what they're supposed to do, and hopefully they get their life straightened around and they don't come back.
Do you have the parenting one that our former colleague, Ann Harbison, helped start the diversion program? And it was parents and kids getting together.
Oh, I am not familiar with that.
That was before you. That was before you, yes.
I'm not familiar with that one. So what we are working on is, Ms. Klingon in her report said that she was able to prove that certain things worked and she was able to reduce recidivism. Mm-hmm. That is what we are working on right now. Our court and courts all across the state is trying to make sure that we gather good data on our juvenile delinquency system so that we can identify which interventions, which diversion or other services we can offer that will really move the needle and make sure that kids don't come back. So that's terrific. We're trying to gather data on that.
Thank you. I do have Justice Coger.
Thank you, Madam Chair. I have just a couple of questions, just one. Excuse me. Does Washington County Juvenile Court have any anti-violence programs? I'm losing my voice.
So we use several online classes through a program called ACCI, and it's the Casey Foundation has put together a number of different online classes that youth can take, and one of those deals with conflict resolution, and so it's called Conflict Wise. And so we have an online program that we use called Conflict Wise to try to reduce some conflict. We also
Could you repeat, is it Conflict Wise?
Conflict Wise,
Conflict
WISE. It's an online program that we use to try to help peers resolve issues amongst themselves without resorting to violence. We also have mental health counseling, and one of the things that we have really seen an increase of, which has been super helpful, are those intensive family services that Ms. Klingon mentioned. That those intensive family services means that there is a mental health professional going into the home 2 to 3 times per week, working with the families. And so as conflicts arise, they can help guide and direct and coach the family into ways of trying to resolve that conflict without resorting to violence. So those are specifically more for those cases where you've got some family dynamic issues that you're trying to work through that would reduce violence.
Okay. And the next question is, you mentioned a while ago about if a child has a gun or the charge, they're going straight to detention. Okay. What about any gun education classes, like safety classes and storage for guns? Because, you know, there's so many guns everywhere, so.
I'm really glad that you asked that question. So we do have a problem with guns and youth. And these youth are buying the guns, they are buying defaced guns, they are stealing guns out of open cars or locked cars, or they're getting them from their parents. We do need to do something that addresses that culture of I need a gun to keep myself safe. And so I've been working on that in my first term, and we finally have gotten something off the ground. We have a provider who is going to start doing we're calling it a gun intervention class, and the youth are going to learn about, and their parents, it's youth and parents, and they're going to learn about proper storage of guns, and then what kinds of things can go wrong with guns. And then it's also going to include an element of group discussion of teens, parents, and then the mentor to talk about factors that led to a possession of gun and how we can do better. So I just authorized that class to take off, and so it's going to start here probably in the next month or so. We'll have our first youth who are going through it. I think that's kind of a stopgap measure, so at least we're getting that far. In other parts of the state, they have a much bigger program called Gun Violence Intervention, the GVI program. I don't know that we need to replicate that necessarily, but I am hopeful in this new term, I'm hopeful to be able to partner with law enforcement and other stakeholders to try to work together on that, because it definitely is an issue that we need to tackle. But yes, we do have a program that we are putting in place now that will address specifically gun violence.
Thank you so much. I appreciate all of that.
Is there a reason, or what is it that you hear from the youth for their need to have the gun?
Well, now, mind you, their frontal lobes are not completely
No,
formed.
I understand
So they
that.
think they need it for protection.
Okay.
I don't think that they're able to really think through that. I mean, there's really no good outcome of a youth having a gun, because either they're going to use it, which will end badly, or they'll hurt themselves because they're sticking it in their pants and, or their sock or whatever. And so, I mean, there have been youth who have gotten very serious charges because they had a gun and it went off mistakenly, and then they've hurt somebody. So, but they think they need it for protection. And I don't know that they have a lot of thought past that where they can really articulate how they think they're going to stay protected from that. I do think we need to think about the gangs in our community. I think that that's real. And I think that there are youth who feel pressured by gangs to engage in certain activity. And sometimes their parents are not, at least at a minimum, not able to protect them from that. And sometimes they are contributing to it. So that is a problem that we have to face. And so I think that I think that it's going to take the court working with law enforcement officials to try to come up with a sort of cohesive plan about how we're going to try to tackle that.
Thank you. I have Justice Bronze.
Thank you, ma'am. Judge, very interesting program here. And I'm an avid hunter. And I have a lot of guns. And I'm very pro-gun. However, I believe in teaching kids to properly store and use of those guns, especially handguns, which they shouldn't have. But my question is, have you all entertained the possibility of going to the grade schools or the junior highs and presenting part of the program to them at that age before they ever get to you all?
We have not developed that as a part of our program at this point, largely because our funding and manpower is really focused on the juveniles who have been adjudicated delinquent, or those kids who have been alleged to have done something and it's, some kind of diversion. I think it's a great idea, and maybe we can work with the schools to incorporate that. We did have a lot of conversation in coming up with this program of gun intervention that we have developed. We had a lot of conversation about teaching gun safety and how do we go about that while still trying to say, you shouldn't have a gun. Not hunting. I mean, there's no kid in JDC who has a hunting rifle. That's not what we're talking about. We're not there are plenty of people who are out there hunting with their families and are perfectly fine with that. We're talking about kids who have bought some kind of defaced fire handgun off the internet or whatever, and they've got it, and they're taking it they're shooting it out of their car at an apartment going by. That's what we're talking about. So if they were hunting with their gun, that would be, condoned activity that, is under guidance and discipline and fair enough. But we're not talking about that. We're talking about kids shooting at each other or shooting into apartment buildings or shooting into, bicyclists on the trail or something. That's the kind of stuff we're trying to stop. And so, there's that element like, yes, you want to teach them to be safe with a gun, but at the same time, you want to tell them, don't be using a gun to start with to solve your problems.
How much are you talking about you would need? Could you kind of maybe sit down and think about it and give me a rough estimate of what you would have to present a program like that?
Sure.
Okay.
Okay, I've got Justice Pond.
Thank you for coming. It was a very interesting presentation, very educational. How many social workers does the county employ that might work with the youth, the children at JDC directly?
That's a better question for Ms. Klingon. She has social workers. I know there's two. There's Ms. Klingon and Michaela Wallace, and then they always have interns. And I think they have maybe 3 or 4 interns? Two interns.
Okay,
There's not very many.
well, that's good. I just wanted to, I had not heard for a long time how many we had, but, and that's a pretty fair number for the number of children that they have to
Well,
work
as
with.
Ms. Klingon was saying, we really don't, we recognize that the juvenile detention center is just that, and it's
Yeah.
not a treatment facility. That's the other youth who sometimes end up in JDC, is sometimes they will have been, the family of the youth will have admitted their youth into a residential treatment facility, and then that youth will get into a fight there. They'll either fight the staff or they'll fight their peers, they'll cause property damage, and then the residential treatment facility will call the police and have them arrested and say they cannot come back because they violated the rules of the residential treatment facility. So you've got a person who has a mental health condition, that's why they got into the residential treatment facility. The facility that you sent them to treat them is saying that they can't handle them, so they send them back to JDC. Well, JDC is not appropriate, it's not a place for them to go, but you can't really just let them go without any support because that puts the public safety at risk. So they may sit at JDC until we can find a placement somewhere else. That happens more often than I would like.
It's good to know we're equipped. We have trained personnel that can manage this sort of thing. I want to tell you, thank you again. I appreciate it. And I'm going to tell you again, congratulations on your reelection.
Oh, thank you so much.
I have Justice Lopez.
Thank you, Chair. Thank you, Judge, for being here. My question, as it pertains to gangs, so to speak, what programs are we looking at to interrupt that sort of violence? I know we talked about violence interruption, like Violent Wise, but I know that there's other programs, and admittedly a little more urban character, things like I believe Build, which is formerly Bang in Chicago, in which there is like former gang members or people who have been adjudicated and reformed from gangs, and then they go out into these communities and help kind of interrupt that pattern from repeating with young people. I believe that Benton County has a program that is similar, that goes in and looks for these things. Are there obstacles that you see for why we don't have a program like that? Is it a funding thing for us, or has there not been an appetite for something like that?
I don't think there's been an organized effort.
Okay.
I mean, that along with the gun violence is sort of a priority of mine in this, in the next few years. And so I think what it's going to take is coordination of the two divisions of juvenile court and then the law enforcement people to get all on the same page. And so I'm hopeful in the next few years we'll be able to make some positive steps on getting that together. I don't know, I mean, there may be a money ask at some point, but I don't think that that's the initial problem. I think that we have to figure out what we want to do to intervene. I think that's probably what we need to do, is figure out what are the programs that can work to help with that, and then figure out what we need.
I think that's an exciting prospect. I know that those programs have been really fruitful in, I believe, Chicago and Baltimore as evidence-based solutions that kind of help reduce youth violence. So in whatever capacity, we can help. I know that I'd definitely be on board for that. Thank you, Judge.
Anything else?
Thank you.
Okay, thank you so much.
Thank you so much. Have a great
Appreciate it.
evening. Moving on to new business, we have item number 9, a resolution requiring the Stewart Family Christmas Lights LLC and the Stewart Family Fireworks LLC to stop operations immediately until granted an approved conditional use permit, large-scale development permit, and floodplain permit in accordance with Ordinance 2025-044. This was introduced by Justice Massengale. If you'd like to speak on this.
Thank you. The first meeting that I attended on this court, during citizen comments, there was a gentleman who got up and described a business that was operating within the county that had significant impact on the community, and was operating without a conditional use permit. I've since, over the last year and a half, seen the amount of effort that different businesses and individuals have gone through to apply for a CUP, and in a lot of cases get turned down. But they went through the proper process. They applied for the CUP before they opened their business and before they began impacting the community. So the more I learned about this business, it's been operating at least since 2019. There was a news, actually KNWA, I sent out an email, KNWA did a news report about this business in 2019. And at that time, the Judge Joseph Woods was trying to work with this business to get them a CUP. So they've been operating a long time, knowing that they need a CUP, and have failed to provide the proper application. I don't know all the details about why they don't have a CUP, but I do feel like it's wrong to make everyone else that wants to open a business go through the time and work and effort, and then a lot of cases get turned down. And we're allowing this company to operate with significant impact on the community, and it appears that we're not taking any serious effort to rectify that. So that's why I recommend that this go to the
This
full court.
resolution?
Yes.
Just to give some background to, is there anybody from the Stewart family here that will speak to this? But I believe that back when they first started their enterprise, that was under our former director, Nathan Crouch, and Juliet Ritchie. And they stated they didn't need a CUP because it was a temporary operation, meaning seasonal. Same thing with fire stands that pop up here and there. They don't need a CUP because it's only a temporary operation. However, it has grown into a larger permanent development, and they are in the process of getting all of their floodplain information, and engineers are working with them to apply for a CUP before. And the reason why they hadn't was because they were instructed by then planning director, you don't need one. And so I'll let you speak to the rest of that. Yes. Go ahead. If you haven't made a motion. Go ahead.
I just want to be sure, we don't have, as I understand it, a motion yet or a second.
Correct.
So do we need to do that before we start
do.
having any discussion?
We do, thank you.
Okay, thank you.
Would you like to make the motion, Justice Massengale? One moment.
Yeah, I'd like to make a motion that this go to the full court.
This resolution,
This resolution, yes.
I have a motion to pass this on to the full quorum court for approval. And I have a second by Justice Lemming. Now, thank you. Further discussion. I have Justice Bruns. Yes, sir.
Thank you, ma'am. You know, I think what J.B. Maskengale has made a great point, that we need to get consistent with the CUP stuff. And we had talked about that back when we were looking at the zoning, and we were told by the judge that we would be having meetings in reference to it, and we've not even talked about it. So I don't have a problem with where he's wanting to go right now, but you know, I just want to present that we need to be consistent and we need to be fair. And we have a business on Kenneth Price Road that I've brought up to this body on several occasions over the last year that is a working junkyard and is spreading trash everywhere in the neighborhoods. And this, I have asked the sheriff to go out. He went out. I've asked Mr. Lester to try to do something about it as far as adjudication. He says, oh, I sent him a letter
Excuse
and
me,
it
are we
came.
talking about Stewart Family Farms?
I'm talking about
Okay,
being
then
fair.
Okay, you can stay on point that we need to be fair, but it has to remain
I'm trying to make a
relevant
point.
to Stewart Family
I'm trying to
Farms.
make a point where we're not being fair with some people, and then we're gonna force them to come in and do a CUP when we've got a business out there that's been operating for 11 years and is not even, we're not even paying any attention to them.
Okay, but point well taken. I've got Justice Dean.
Thank you, Chair. What I'm seeing here on this ordinance is 2018, or this resolution. Is 2018, 2019. They were asked to get a cup. 2020, they started increasing business, was asked to get a cup. 2025, multiple times was asked to get a cup. And this is now just coming out. I mean, I think that
I believe that if you would give the Stewart family representative to address those.
I think the discussion is at the horseshoe and should stay at the horseshoe until we're done. They can provide to citizens comment or whatever else.
That's not true. That point of order is not accepted because this is part of the discussion in order to give forth information. I have Justice Lemming.
All I want to say is, since I've been on the court, the problem with our planning and zoning, we have no enforcement. There's the judge and the guy sits beside him is our enforcement, and they pick and choose. They pick and choose. We do not have no enforcement.
That's a point of order, because that has nothing to do with the Stewart Family Farm. If you want to make the argument about this resolution, then that is what we're going to do. It's about this resolution, not about the whole zoning process or the CUP process. Thank you. I have Justice Massengale next.
Thank you, Chairman. A couple of the points that you brought up in your statement. You know, I think a lot of times businesses will start off small, and there's a lot of people with home businesses that don't have an impact on their neighbors and their community. And if those businesses grow, at some point, they do begin to have an impact on their community, and I think they cross a threshold where they're required to get a CUP. If you look at the news article, the KNW news article, at the bottom, there's documentation from 2017 from then Planning Director Nathan Crouch requesting, informing this business that they needed a CUP. So apparently by 2017, you know, they crossed that threshold where, you know, the planning department determined that they needed a CUP. So just want to make that point.
I have Justice Lyons, and then we're going to hear from the Stewart family representative.
Thank you, Madam Chair. Two things I have on this resolution. The first one's technical. The resolution has words in it that makes it sound like an ordinance, which is inappropriate, so somebody needs to come up with some different wording if we're going to pursue this. I didn't come up with different wording because I don't think we need this resolution. The current ordinance provides for the ability to fine businesses that refuse to comply with our ordinance. Now, the process is a bit dysfunctional due to the leadership of this county. But what I found as I tried to move through that process recently is basically the planning department needs to make a determination whether it's compliant or not, and then serve notification. Because as we went through a lot of discussion on this, we all said, we don't want to just go start finding a business. We want to give them the ability and the chance to resolve it. Based on all the information that I've seen, we've given plenty of chance for this business to resolve themselves. So I think the next step needs to happen, and unfortunately, the next step has to occur from somebody contacting the sheriff's office, filing a complaint to have it investigated for fines to be assessed for being non-compliant. So I can't support the resolution because I don't think it will do anything for us, one. Two, it's not needed. We have grounds in the ordinance to take care of the non-compliance through starting to assess fines to the property owner who refuses to efficiently obtain a cup, at least show some good faith that they're trying to get there. And given the background that's been presented in the resolution and the whereas and other information I've been able to gain, that good faith isn't there. So I just think, basically that next step needs to be taken. Reach out to the sheriff or contact the planning department, verify that the appropriate notifications have been made so they're not jumping the gun on anything, and then they'll take the appropriate action. Thank you, Madam Chair.
Thank you, and as a reminder, we are the leadership of this county. We are responsible for passing CUPs. I'm going to have I said I was going to have, you can ask your question after the representative has an opportunity to speak. Go ahead, sir. Please give me your name.
Yes, thank you. My name is Brian Thomas. I'm the attorney for the Stewart Family Christmas Lights LLC and the fireworks one as well.
You're not recognized, and he is speaking. Thank you, sir. Okay, but your mic's not on. You haven't been recognized. What is your point of order?
I think we're outside of our process. We have never allowed people outside this horseshoe to join into this discussion as long as it was at the horseshoe. That's always came after the fact, with the exception of when we're actually looking at a special meeting for a cup that we've made those changes. So I think we're out of process, and we should stay with our normal process.
I disagree. My decision has been appealed. All in favor of allowing Justice Coger to speak before an explanation, or anyone else, indicate by raising your right hand. Okay, it's unanimous. I'm sorry, I apologize. The ruling has been overruled. I have Justice Coger.
Thank you very much, Madam Chair. I don't really have a question. Well, I might have one here in a minute, but I just want to say that the thing that worries me about this, it's kind of like we're starting a precedent. We're starting like, I know there are other venues in this county that are operating without a CUP. I know that because people tell me that. Now, do I know that for a fact? No, but I believe them when they say there are some. So why is it that, I feel like we're starting something here that we don't want to get into, because there's all these others out there too. And like J.B. Burns said about being consistent and fair. So I want to know, and when like lately when we've been sued over CUPs and I've been in depositions that I've had to answer interrogatories, the question that the attorney will keep asking me over and over is, what did you know? What knowledge did you have? Why did you vote the way that you did? What, to want me to back up my position. And I don't feel comfortable doing that with this resolution, because I don't know the things that we've set out in here, that this says. I don't know that those, I'm not familiar with it. I just don't know. So I don't feel like I can say, I can do that. And I'm also wondering what happens if we pass this resolution? It's, what's going to happen after that? And is there any possibility that it was grandfathered in? That's one, we can ask that in a minute. He can answer that in a minute. But this seems to me, and are you acting as county attorney tonight, JP?
No, ma'am, I'm acting like what it says right here.
Okay, well then,
I'm supposed to be helping her look for people that want.
oh, okay, I was just kidding. So since we don't have a county attorney here tonight, but I would think that if our county attorney was sitting over there, he would say this is the very definition of arbitrary and capricious. Thank you.
Justice Lyons.
Thank you, ma'am. Well, first of all, this isn't a cup. So the ordinance around cups and approving cups kind of is not relevant. And again, I'm on the position, I don't think we need it. I think we have the grounds to take care of it. But inconsistent, I want to talk to inconsistent. Our zoning has always been based on complaints. We don't have somebody drives around, says, hey, they're out of compliance, hey, they're out. It's based on complaints, right? We've had citizen complaints on this property. I've got I got 3 or 4 that I've either started. There's one I've been started since my first term and still trying to get it taken care of. A second one that's been going just about as long, still trying to get it taken care of. And it's just going through that process is very dysfunctional. I think the latest things that we've done with, in the ordinance, identifying the sheriff is the one that goes out and identifies and applies the fines. I guess I don't know the actual steps, right? The steps I do know is we want somebody needs to complain. So I'll take it. I took it on myself. I got one out on 412. Looks like a frickin' salvage yard. There's cup says, they have a cup, but it says they're an auto sales. Well, you're a little bit out of compliance with your cup. So they have a cup, they're just not compliant with their cup, right? Been working this since my first term to try to get it cleaned up. From my opinion, it's very easy. Put a fence around your whole frickin' property so we can't see it. We'd be done, right? But it's been delayed and delayed and delayed, right? Working with the planning department who did go out, talk to them, serve notice, right? Kind of got stymied. So now where we're at is I now need to take that step I just talked about for this one previously is I need to contact the sheriff's office and says, I know notification's been done. I need this investigated. They're out of compliance with their cup. Let's start fining them. Then they'll contact again Director Ada to make sure what I've told them is correct, which they should do. They shouldn't take my word for it. They should. Director Ada is the one that makes the notifications, that sends it out. He has that documentation, which he does for here. I think we got a email from Director Ada today with a whole zip folder full of notifications and correspondence. Now, I haven't looked through them all yet, but I think he did send them to all of us. So it is in your email. But again, it's consistent to the point that it starts with a complaint, whether that's a citizen's complaint, one of us decides in our district, that's unacceptable, we need to have something done, and we start the complaint, which is what I've done for certain areas of my district, or that type of thing. So I think we are consistent from that standpoint on how we how we look at it, how we monitor it, and decide something is or is not out of compliance, okay? We just need to take those steps. And quite honestly, you just, as a JP, if you're involved, you just have to stay on top of it and keep pushing and pushing and pushing. That's just the way it is. It's the way it's been since I started.
Okay.
Thank you, Madam Chair.
Justice Bruns.
Thank you, ma'am. I'd like to call a question, please.
As far as voting,
Yes.
without allowing any explanation,
Call a question. That's a proper procedure.
yes or no? There were still people in line that wanted to speak. We can vote. All in favor of ending discussion and voting, raise your right hand by signifying that yes. Say that again. I can't.
All in favor of
Ending discussion. That motion fails. All opposed, raise your right hand. That motion fails. Justice Massengale.
So really what this resolution does is makes, huh? Right, and it's not
Justice
necessary.
Lemon.
It basically
Justice
says,
Lemon.
it says, this business needs a CUP. I don't think there's any question about that. And it says, we need to follow the ordinance. This has been going on since 2017. The process is broke. I don't know what else to do. There's got to be another solution other than this, but this is the only one I could come up with. You know, so if you feel like this needs a CUP, I mean, I urge you to support this, but, you know, we do need a solution to the problem of businesses that are operating without a CUP, because it's way too hard for businesses like the Gully Ranch to come in here. They hire architects, they hire lawyers, they go through all the process, and then they get told no. And then we've got businesses that just operate for years and years and just ignore the wishes of the county. So,
Justice Fleming, can we please allow?
Yes, sir. Yes, ma'am. Thank you.
Yes, sir, Sergeant.
Mr.
Sir.
Madison, you've done a wonderful job bringing this and pushing this. This really does need a CUP, and this does need to stop. But this horseshoe is not the law enforcement for this. You know, Brian Lester's supposed to send letters to anybody that's out of compliance. You talk about 2 or 3 or 4 in your districts. 2 of these guys, JPs did. I could drive you around and show you hundreds of businesses in District 13, plumb from lawn mowing, plumb from cleaning, plumb from, I mean, you can name all sorts, caterers for food. And that's one of my big downfalls of where I've been struggling hard on trying to get some new zoning and planning. How do you do this? I mean, how do you stop the 150 mall paw shops in my district and say, okay, now we got new laws starting today. Everybody from this point on has got to go through all the process that you're calling. And all these people that's beside us, that's been in business for 20 years, hadn't had to do nothing. It is a struggle to figure out how you're going to balance that. And we're not police officers. That's not our job. And Sam cannot publicly keep up with all of the stuff that he does every day and go out and police it. That's why we got to have a fire marshal. That if we're going to do planning and zoning really good, we're going to have to bail off in deep and do really good and have the people to enforce everything that we're trying to do. But I struggle hard with trying to figure out which way to go, to how to get over that hurdle to get to where we can go there. But we've got to go there, because this Christmas deal needs a CUP. I mean, I've been told several times by our county attorney that it's a once-a-year deal, and by our zoning and ordinance laws that we have now, they do not have to have, I call BS, I call that's not true. I feel like they're a nuisance to a lot of people. But there's 1 million people that love that place, and they go out there and they take their kids and they enjoy it, and it's really a nice thing for kids. But on the other side of the coin, narrow roads, traffic, it's a nightmare. So they need a CUP, so thank you.
Justice Dennis.
Thank you, Madam Chair. I've read something that I think sums it up for me. I don't mind voting for a resolution because I know it doesn't have any teeth. A resolution has no teeth. It's not law. It's not legislated. It's just a resolution. It's a feel-good. But that's beside the point. But I just want to read this if I could. Yes, the quorum court, the legislative body of a county government in Arkansas, made up of justices of the peace, has the authority to address issues like this under its broad local legislative powers. But with significant limitations, it cannot directly rule like a court in a private dispute between neighbors. Instead, it can pass ordinances that regulate potential nuisances, preserve peace and order or address dangerous or noxious activities on county property or in incorporated areas. So we need to do what Willie said. We need to get ordinances and laws in our books that takes care of this. We're not to say, this is the winner, this is the loser. That's not our job. That's not our job. We can recognize that it needs to be done, but that's our opinion. It's not our law, it's our opinion. I've been out there, and it's a large development. I mean, it's not a small business. It may only be open a few months of the year, but they're open more than my little business is, and yet I'm considered commercial property. I pay taxes on commercial property, and I'm not open as many hours as this is. But that's beside the point. The rule is there, so I've got to follow the rule. If we don't have rules about it, they're not breaking any rule, but we need to make rules about it so that everybody knows. Otherwise, we're not discriminating against someone, but we're saying you got to have some. And county folks, we don't like it. We don't want to be told what to do. We want to just do what we want to do. But when what we do runs over onto our neighbors, someone has to say, can't do that. And so the way you say I can't do that is you legislate it. You don't say, okay, I'm going to pick a winner and a loser. So I think we get ourselves in trouble on that. And I don't mind voting on a resolution because a resolution isn't anything. But at the same time, it tells people how we feel about it. So it's a good thing in that regards. If you want to know how we feel, we'll tell you. But we're not going to go have a lawsuit because we broke the rules. So, thank you.
Justice Washington.
Thank you. So I have a question for the attorney. I'm reading in the resolution, and it says that Stewart Family Christmas Lights, LLC was informed by the Washington County Planning Director in 2018. Is that true? That you needed a conditional use permit, a large-scale development permit, and a floodplain permit in order to continue operating your business?
I don't know if I'm permitted to talk yet or not, honestly, because I'm not in the horseshoe, so I feel a little out.
I can't, okay.
But I don't
Well,
mean that in any sort of disrespectful way. I just don't know. I don't know the procedure. I'd forgotten large swaths of Robert's Rules of Order by this point in my life. So I can tell you that there were discussions had in 2018 and 2019.
Sir,
Oh, I'm sorry.
Justice Washington withdrew the question.
Oh.
Does anybody do you have another comment, or can he speak? Do you have a comment? You've spoken 3 times already.
Have I?
No, you.
I wanna, and I'll address you. You're the Madam Chair. But I wanna explain to you that I could not see any other way that, J.P. Massengill could do anything else but bring this resolution before us so we could at least discuss it in public. A lot of the discussion that's been had about this is not much more than hearsay. We've had a planning director in the past that I'm not even sure that he's not here now because he did everything he could to comply with rules, and we had administrators that didn't want to hear about it. He finally gave up, went and found more honest work because we had administrators that wouldn't enforce the rules, the regulations that we had. And actually, that's in my district. I should have been the one doing that, but I didn't want to get another planning director squeezed between a rock and a hard spot. if we, you know, and if we've got a case here where, we've got people that know full well when this thing gets in full swing after Thanksgiving, if they wanna not spend an hour waiting in line to get to their own house, they better get home by 3 o'clock in the afternoon. And if they've got a job somewhere, they can't get home that early. That's where they are. They're in a traffic jam just to get to their house. That's a kind of an inconvenience. It certainly is. I've looked at the safety issue on that. What do you do? How does an ambulance get there? There's a lot of trees and things there. There's places where you couldn't get somebody out of there by helivac, out of somebody's backyard that's lined in oak trees. You can't get there by the road. We've had elderly people that lived in that neighborhood that I genuinely was concerned about, up in their 90s. It's a little bit of a relief to me that we don't have to worry about them anymore. They've passed away. They're in a better place now. But I'm just saying, if our county judge is not, and our county attorney is not gonna respond to these complaints, we need at least be here and discuss it openly. I appreciate, like I said, J.P. Massengill bringing this forward. And I'm telling you, I didn't do it because we've not had a response to the public outcry. We've had a planning director in the past that took records of people calling in the complaints and took records on it, and then his boss letting him know they didn't want to hear about it. And you talk about cease and desist. Well, you just quit writing this stuff down, and we don't want to hear about it. It's a very uncomfortable thing. I've got friends on both sides of this thing, and I'll tell you what, I might not have friends on but more than one side of it after this discussion. I might not for quite a while anyway. But it needs to be said. I'm going to look at you and tell you thank you again for bringing it up. Whether we ought to be talking about it or whether we're out in order of talking about it or not. I don't disagree with this other fellow for saying we're out of line doing this. But thank you, Madam Chair.
Thank you.
I appreciate it.
I have Justice Hires.
Thank you, Madam Chair. I too, like Robert Dennis, do not like resolutions. I really feel like it's a lot of like, we feel, however, I want to say to J.P. Massengill that I appreciate you bringing this because what else can we do? And I agree with you on that. You know, I am a little concerned that we don't have representation here tonight, so I don't know if we're out of line. I don't know what that is. So being that representation's not here, you know, I agree something has to happen. This is absolute chaos for the neighbors. We've been hearing about it for years, ever since I've been on the quorum court. I know people that live out there that feel like they are prisoners in their own home for the entire Christmas season. And so while I'm nervous about there not being any legal representation here, I'm gonna go ahead and support this because I figure if this is a big deal, our legal representation would have let us know that there's a problem. So, thank you.
My question is, does the roads department, has anybody requested that the roads be widened? I mean, that's something I don't know. Do y'all want to continue to discuss this or allow? Well, you're not next, sorry. You just go on and eat that delicious almond brittle that somebody gave you. This is your last opportunity. I'm sorry, Dr. Massengale.
I promise you, this will be the last time I'm.
Hold
My
on, just-
only problem with,
I have a point of order. Just 1 moment, please.
okay.
Thank you,
Justice Washington.
Thank you, Madam Chair. I believe that according to Robert's Rules of Order in the Rules of Debate, that we're allowed to speak twice, and several people have spoken, they've exceeded
Several
the
times.
twice.
Yes.
So I would just ask that if you know that you've already spoken twice, to please just go ahead
Turn off
and
your
turn
mic.
your mic off.
Thank you. You've only spoken once. Justice Dennis?
I can remember a few months ago, it felt very much the same as I do right now, and I didn't speak up. I'm going to speak up, be what it may. We were wrong when we went with emotion and when we passed Eagle Crest. So a little caution to you is we've got to do the right legal thing. It's not about emotion. It's about legal. And if we get this wrong, costs us another $500,000, then shame on us. So if we're not sure, be careful.
You've already spoken twice. Thank you. Are you going to speak? Okay.
Yes. So this will be my second and last time.
Wait a minute. You need to queue up again. There we go.
Yes, this will be my second and last time. So I think in a way I agree with everything that everyone is saying here. Unfortunately, when we vote for this, I'm going to support it because, as JP Heyer said, we've been hearing about this for years. We've had people during public comments to come and talk about it and all of that. And so just looking at the resolution at face value, if those things in there are what happened, and we don't know because we didn't get an answer for those, so I have to assume that they are if they're in the resolution, then this business has had plenty of opportunities to rectify a situation that they're intentionally choosing not to. And for me, that is what I find problematic. We can't go on handshake agreements. Oh, they were told this one thing. Okay, great, but if they were told that in if in 2018 they were told something, in 2019 they were told something, in 2020 they were told something, in 2025 it says they were told something multiple times. We have to be sure that as a body, that we send messages to people that, listen, when there are rules in place, as the quorum court, we expect you to follow them. Is this the best way to do it? I don't know. And JP Massengale, I do also want to reiterate that I do appreciate you bringing this forward because this is the only way that we could discuss this and talk about it. So until we can come up with what the best course of action is, I believe that supporting this resolution really is the way for us to go. We cannot always be concerned about, oh, let's not say this, we're going to get sued and all of that, because JP Dennis alluded to the Eagle Crest situation, which was totally different. That was different. This is not an emotional thing. At face value, we're looking at a resolution that says that this company was given multiple opportunities to do something different, and they didn't do that. So I would just urge us, I know we could talk about this, well, we really can't talk about it all night because we've all exceeded our 2 times remarks, but we just need to go ahead and vote, support this resolution, and if we need to do something else, we have a county attorney that can instruct us in that way.
Okay, now, sir, will you please give us...
Because that was unnecessary.
Who?
When I asked him the question, he was like, well, I don't know if I can talk and all of this stuff. Like, that was unnecessary. When I asked you if I could ask him a question, and you said that I could, and then he didn't. And so, disrespect to any of the colleagues is not.
I'm going to ask if you would just apologize anybody was offended by your comment earlier, so we can proceed with some information. I'm just trying to listen to both sides. I've heard this argument from neighbors. I want to hear from the Stewart family on the accusations. So if you would just humbly apologize if anybody took offense to what you said earlier, if you were allowed to speak or not.
I do apologize. I was not in any way intending or meaning to disrespect. But when I open my mouth to speak, I'm responsible for what comes out of it and how it lands, and half of speaking is the other person hearing. So I do sincerely apologize, because I meant no disrespect to you or to the members of the Services Committee or the Justice of the Peace. So
Thank you.
I do apologize for that.
Is that accepted? Okay, it's accepted. Thank you, I appreciate it. Do you have a copy of the resolution?
I do, yes.
Would you
Justice.
mind, I want to look at both sides. If these are some accusations that have been made, and either say, yes, we are here, or no, we're there, and this is what we are doing now, today. Or if
Yes.
you'd like to start with where we are today.
Yes, I'd be happy to. I'll keep it brief. Where we are today is we are in the process of pursuing a CUP and the large-scale development permit and the floodplain permit. The past couple months or so, my client's been working with the Arkansas Department of Health to get a septic system out there that is certified and permitted and all the words that the Arkansas State Departments like to have on things. I honestly don't know if it's certified or permitted. It's one or both of those. And then I spoke with Mr. Ada, not last week, but it was shortly before the quorum court meeting where this was tabled and sent here, to ask him, what I want to make sure we're doing the steps in order. He confirmed that getting that taken care of with the Arkansas Department of Health was step one. Step two was to start working on the floodplain development, and he basically said that needs to be satisfied before the CUP can be presented and considered, because that floodplain issue is in his eyes, I understand the eyes of the county, a pretty big issue. So that's what the process that we're working on and have been working on, and started the process of working on it even last year when my client first came to me about this issue, and we tried to get it taken care of quickly as we went into the back end of 2025, but it was, kind of realized there wasn't a quick way with the floodplain issue in particular, and it was just going to take time. So that's where we are as of this moment. Some of the things in the resolution, just talking about face value, that stood out to me. I'll just give you just the language of cease operations immediately. It is seasonal. There's no operations going on currently. I know there were discussions in 2018 and 2019, and that's been a while back, and people remember conversations differently. I can tell you that if you put my client under oath, he would tell you there were conversations, but he did not understand those conversations as saying he was absolutely required to get a permit. But there were discussions about possibly that being the case down the road. I will point out, people have mentioned, a couple of justices have, that conversations were had in 2020 with my client about a conditional use permit, and to my knowledge, that didn't happen, and that's not also reflected actually in the resolution. It merely says that continue to not only operate, but to expand in size and scope every year since 2020. There's nothing in the resolution that actually says additional conversations were had in 2020 about a conditional use permit. I'll also note there's nothing in the resolution that says there were conversations or letters or any kind of thing in the year 2021, 2022, 23, or 24. So to the extent the resolution draws a straight line from 2017 or 2018 all the way through 2025, as if this has been ongoing and year after year, this has been brought to my client's attention, that's not in line with either what the resolution says or what my understanding of the situation is based on my conversations with my client. There's the last whereas paragraph on the bottom of the first page. Every night, not just Christmas, this property is lit up with thousands of colored lights, signs, and spotlights. that may be referring to that it doesn't just happen on Christmas night, but is other nights during that season, which would be accurate, but it certainly is not lit up every single night. Just from the perspective of my client looking at this on behalf of my client, there is definitely a sense of being singled out. I'm not aware of a precedent where the Services Committee or the Quorum Court tends to pass these resolutions. I can't think of a better word, so I'm going to use this one and apologize for any offense, but sort of targeting a specific individual or specific business. So it's a little odd. It struck my client as odd, and I as odd that would be the case here. And then looking at the resolution, just some of the things that don't line up or things that, from my understanding, are factually inaccurate. Also, I would ask the committee to consider that as well when it's looking to whether or not to refer this resolution to the Quorum Court out of committee. Hopefully I answered the question that Justice Washington was asking initially. I certainly was not trying to avoid that question. Most of my public speaking comes from Baptist churches, and rules are very loose in Baptist church meetings. So I tend to speak humorously, and sometimes that comes off as glib when I don't intend it to be. So again, I do apologize to the members of the committee and the justices, and especially to you, Justice Washington, because I was speaking to you, and again, I'm responsible for not only what I say, but how it's heard. So I apologize again, and really that's kind of the only statement I wanted to make about this from my client's perspective.
I do have a question whether or not your client, have they acknowledged the traffic during the Christmas season or the holiday season? And has anybody contacted the roads department asking for either a widening of the road or something to help the flow of traffic?
We're definitely aware that it causes, it's a lot of traffic on the road. I'm not aware of any contact with the roads department about that. I know with the engineer that we've retained to help through this, we've talked about traffic and talked about that aspect of it and how to address it when we get to the point of submitting the CUP after we take care of the floodplain issue. And I know a couple of things that have been looked at are parking in other areas that you can shuttle people to it, so you cut down on the congestion. So we're aware of the traffic and taking measures to make that flow smoothly. I'm not aware of any discussion with the road department about widening the road. But I do know that aspect of it is a consideration as we move towards getting a fulsome CUP submitted.
I think that needs to be addressed and answered and have a solution for it as you move forward for the CUP. I have
understand.
Justice Wilson.
Thank you, Chair. I had one question just for the purpose of clarification and possibly a motion, but sir, did you say that they've begun to pursue a CUP? Did I hear that?
We are in that process. Yes,
Okay.
Justice.
Okay, thank you. I'd like to move to postpone this 1 month for more than one reason. If they are currently pursuing a CUP, we'll see where that is. This may make all of this academic. The other reason is it's been pointed out that there's several things here that might be inaccurate. We would need, I think, it to be rewritten in some places before it comes before us. So, and I would even offer some amendments myself, but I don't want to do that right now. I move to postpone 1 month.
I have a motion by Justice Wilson to postpone voting on this resolution for a month. So therefore, we're going to move it to the May or end of April. The next, let's just go the next. When it needs to be County Services meeting. And a second by Justice Dean. Do I have any further discussion? Justice Pond?
Yes, ma'am. If we postpone this for a month, does that mean we'll be able to discuss it again when we bring it back up next month. I'll ask Ms. Coger there, she's got the Roberts Rules book, right there.
I ruled that yes, we can.
Okay, all right, there we go.
Ms. Roberts
That's all we need.
or Ms.
Thank you.
Rules? Is there any further discussion?
Thank you,
I
Robert.
have Justice Dennis.
Thank you, Madam Chair. I would vote for that, but I think that it's unfair that we've done all this and we've not heard the discussion come from the other side.
I agree.
They came in two different meetings for a long time, and we've not listened to them. And I would like to listen to them, see what they have to say. We've listened for one side. I want to hear the other side
I
before I
agree.
vote. So I'll be glad to vote for it, but I'm not going to vote for it unless we have discussion from the other side.
Is that permissible? I mean, is that acceptable?
Go ahead.
Where did you go? I'm shutting off.
Thank you, Chair. It's fine with me, but I think I proposed something similar one month, saying we wanted to hear something from the people who were here, and I was told that sounds like we're opening ourselves up for litigation. Now, I didn't agree with that statement, but that's what was said when I proposed it many months ago. But I'm fine with it tonight,
Point of
if
order,
you're
if
asking.
you have a motion on the floor in a second, you either need to deal with it or take it back.
That is correct. There's a motion and a second on the floor, and that needs to be disposed of first before we can have any further discussion. But once that is ruled to postpone it, then it's end of discussion, and the other side will not have an opportunity to speak.
Could I withdraw my motion until later?
Yes. Make a formal motion, please.
I withdraw my motion.
The motion has been, for postponement, has been withdrawn by Justice Wilson, seconded by Justice Dean. Can we continue the discussion? Oh, there's no need to vote. It's been withdrawn. Okay? Thank you. We're going to have discussion by the neighbors. Thank you,
Thank you.
sir. No.
David Baltz, 4459 East Wyman. First off, I'd like to offer the committee and the justices from the last quorum court an apology. I think you can see by the discussion how emotional this is for, neighbors. And just how, we're talking about how defunct this is. This is why we're sitting here today looking at this, because this is the only traction we can get. I talked to you last time at the quorum court that your county officials are struggling to get any traction to do anything with any of this. Whether there's multiple business out there, I have no doubt. But the issue today is the Stewart's Family Light Show and the Stewart's Family Fireworks, which operate year-round, which I'm pretty sure is not legal on its own. But there is always operation out there year-round. So get out of your mind that it is only seasonal, because they are running equipment, they are running paid personnel, they are firing off fireworks to do test fireworks for people that are buying them out there. It is going on nonstop, and trash is always being created. Some other things I'd like to tell you also, just so that you're aware, because I think the facts need to be really importantly stressed here, is that there are multiple forms of pollution. You guys have heard of minor pollutions. I'll call it minor. I think to some people it may not be, but light pollution is a serious thing. There was one night, actually 2 nights, where we had low-level clouds and light, so much light coming off low-level clouds that it drew migratory birds off of Lake Sequoia. I'm talking about cranes that circled the lights in the middle of the night for hours. I don't know where they went. I went to Sequoia the next day because I frequent there to fish a lot. They were not there the next day. I hope they're okay. We have waste, trash everywhere. The good thing about this is I've gotten to meet a lot of my neighbors. I really feel bad for a lot of my neighbors, some of which are related to the Stewarts, some of which have asked the Stewarts to clean up the trash. This is property that is along a riparian area. If you don't know what that is the area that follows a river. The river that it's on is the West Fork of the White River. That is the major fork, one of the major forks, 3 forks of the White River that supply our watershed, the Beaver Lake, right? That's where we get our water, if you're not aware of that. On the Stewart's property is a 24-inch high-pressure intake line for our wastewater treatment facility on the east side of town. That is a high-pressure line that runs at a gradient. So that means if you're driving along the county and you see a big old black pipe that sticks out of the ground and all of a sudden goes into the ground, that's running raw sewage, and it has to run at a certain gradient. I'm working with the Intellects or whatever the company is that's contracted with the city right now to run the water plant to get information about what rules and regulations are around that. But I can give you heed and some warning right now. That is nowhere but about 6 inches below that compacted subbase that they are putting out in that parking lot along that riparian area. They're struggling right now to get that septic approval from the state because they packed in subbase, which is limestone gravel, all across that property. This is the problem when these companies come in and do this without following the regulation. They've now done things that are keeping them from actually being able to get a permit because they've outstepped what is common and good. So I'm just going to tell you this really quickly and then I'll be done. I really appreciate the time and thank you. Again, I want to say that this is indicative of a bigger issue, and I do apologize for being so upset with the quorum court, but I do want to bring this back down to that your public is here, every quorum court, every planning meeting, working with the county on this specific business, which is causing harm to our community. I'm here tonight to make it clear that it's not about the kids. That's what the Stewart families will say. They've said that many times when I've gone to film the traffic and other things. What about the kids? Well, if it's about the kids, then stop charging money. It's a business, and they're making money off of it. This is about accountability. This is about a business that chooses to ignore the county officials and operate without required conditional use permit. Even after being told repeatedly that one was necessary, a decision by the Stewarts was made to move forward, build, and expand anyway. A little subset here. We've been talking about 2019, 2018, 2020. Can I just get a check really quickly on what year this is? There's been multiple years passing where we've been pushing this business to get permitted, to follow the law. It's 2026. This isn't just happened in 2019 and now we're here today. This has been ongoing. That's why I've been in front of you month after month. This is about a business that chose to ignore the county officials and operate without required conditional use permit, even after being told repeatedly that one was necessary. A decision by the Stewarts was made to move forward to build and expand anyway. They made that choice. Make no mistake, this is about precedent. If the county continues, it sends a message across the county that anyone can set up shop. And I think we've had that discussion today. You guys have. Delay the process, complicate enforcement, and avoid consequences. Not because they legally can, but because they're allowed to. Is that what we support in Washington County? Not because I should, but because I can? This is exactly what this resolution addresses. The resolution restores the county's ability to enforce its own rules. I've been in contact with Sam, I'm not gonna say his last name, not Sam Atta, at the sheriff's office. He's legal representation there. He's gone through everything and said, you get me something from the quorum court, I can take action. That business is supposed to be fined $1,000 every time it opens up without that permit. At its core, this is about protecting shared communities, residential and agriculture areas that are zoned with clear intent. Changes are allowed, but only through conditional use processes, which ensure that neighbors have a voice that impacts the community and are properly, that neighbors have a voice on impacts that impact the community. Excuse me. This court regularly reviews conditional permitting for final approval, but in this case, we've not even reached that step. Years of tactical delay brought by the Stewarts have put us here. I also want to address something directly. There has been public commentary suggesting this is personal and that I'm targeting Stewarts, that this is just simply not the case. And I want to go on public record with this. The ineptitude of this being able to get taken care of has put me in a situation, and my family were either in Facebook or wherever, oh, that guy that lives to the east of him just doesn't like the lights. No, I love the law, and I want my voice to be able to be heard and be part of that law. I think it's a great business idea, as long as you do it correctly. I'm surprised somebody hasn't tried to do it correctly besides them. My concern is not with a person, it's with the process. Any argument that a business should be allowed to operate outside that process, regardless of what it produces, undermines the law. It opens the door for any business to enter a residential area, build, expand, impact a community without ever giving a community a voice. Somebody mentioned like a salvage yard or something. It could be anything to any of us. So it really amazes me as well, just a side comment, that the amount of people that will negate their rights under the law to enjoy Christmas lights because it's not next to them. And that really scares me that the public does that. And I think that's just human nature. But I think if you put any of this Christmas lights, a year-round fireworks sales shop, a salvage yard, a gravel mine, the list goes on and on, right? A home for troubled people, whatever Eagle Creek is, whatever, right? I can go, this is precedent that you have to set. And this not ordinance, but resolution, thank you so much, Ms. Aki, Madam Chair. This resolution helps solve that and get you guys back that time. Yeah, thank you. I know I've had a lot of time and I really appreciate it, but this is about following the law and nothing personal against the stewards. And I do agree that there are a lot of businesses out there that can fall under this concern, and there's a bigger issue that you guys have to tackle. But right now, you have the public, you have your constituents here saying, this is one that we have taken the time to come here to tell you about and have taken the risk against the people that are for it who are not considering the law. Thank you.
Thank you.
Good evening. My name's Jerry Tuck. I live on East Wyman Road. My house is a few hundred feet from the Stewart Christmas lights, and actually own property that joins the Stewart Christmas lights. My family's owned property on Wyman for more than 90 years. The land was always beautiful, a peaceful and perfect place to raise a family. I never imagined that one day a large-scale business would be dropped right in the middle of it. A large-scale business that has no accountability, no oversight, and no enforcement because they don't have a CUP. I know there are many Wyman residents like myself that have felt powerless as this business has continued to expand right in front of everyone's eyes. But tonight, you have the opportunity to change that by making them go through the CUP process like every other business in Washington County. It allows those most impacted by this business to finally have a voice. That's why I urge you to vote in favor of the resolution before tonight. Please give us a voice and make them comply with the ordinance that this horseshoe has passed. Thank you.
Thank you. Justice Wilson, would you like to make a motion now? Oh, we have one more.
Excuse me, I'm sorry. I would also like to speak on this behalf, if that's okay. Good evening, ladies and gentlemen of the board. My name is Joshua George. I'd like to thank you all for your efforts and the energy you put in serving this community of Washington County. You are appreciated, and as a citizen, I'd like to give you my personal thanks. Forgive me, I'm a little shaky. My adrenaline pump might not work like the regular average Joe. I'm a combat veteran, and I'm a little bit, so forgive me if I'm a little shaky. I'm
You're
trying to get
doing
my
great.
point across. Well, I would just like to speak on behalf. Is this nothing new under the sun? I'm an old country boy from Yell County, and we had a guy lived out there, and he had chicken houses. And what happened was, this old boy came and moved in and put a house up next to that chicken farm, and he didn't like the way the chickens smelled, and he didn't like the way everything was. So he tried to have this guy that had been running chickens out of his place for more than a decade shut down, and they had to quit because he put a house up next to him and didn't like the way things was around there. Well, that didn't work out so good for that old boy, and I can't see this being any different than, you know, like I said, nothing new under the sun. Neighbors don't like the Christmas lights. Well, you know, that's all right. I invite you to draw your curtains shut. You know, the Stewart Christmas lights, you guys are familiar with this thing. This is huge in this area of the state. People come from all over Arkansas and even from outside of the state to view this thing. They've made the news like it's been spoken. It's a wonderful thing. It's become a tradition in my family. And not to, I understand and sympathize with some of the concerns of the neighbors. I mean, during that time of year, in that season, it could get frustrating. I'd like to also bring to the attention how these people, they've taken half that property out there and leveled it and turned it into a parking lot to get the cars up off the road and out of the way. This thing is so good, you got people coming from all over wants to see it. They bring their kids, they bring their families. It's something good that's going out into this community. And I know that with all the bad we've got turning up in the world, I'd hate to see some of the good get turned down. This court and this hearing and this whole thing, a letter got put in every mailbox out on that road. And you can see there's a couple that don't like it. And there's a couple that's here to express, and that's their right, and that's great. But if it was a big of an issue like they're being made out to be, I think you'd have a lot more people from Wyman Road out here right now talking about it. Not only that, but it is a seasonal thing, and I think this gentleman's right. You need to be fair on both sides of the coin. You know, if somebody's had to be holding a permit or whatever, they need to do it. But just because the business has gotten more popular and has gotten more attention and more people coming to it now, doesn't change the fact that they only operate from this time of year to this time of year. You know, it's a seasonal thing. You're not going to go out there in the middle of the summer and watch Christmas lights or look at lights, you know. And they've got their fireworks stand that they pop up whenever it's time to sell fireworks. And I can't speak on what they do all year. I ain't out there monitoring them. But I've been by their place many times, and it's far from a junkyard. You know, if you got a law against having your lights up or your ornaments up, decorations up all year long, well, then they're guilty. But as far as, you know, not liking it or something, that's one thing. That's about all I have to say on that topic. I mean, I think that...
And we're going to have to thank you, sir. There's a couple of people behind you.
Okay. All right.
And we really want to get everybody in before we vote on this
Yes, ma'am.
postponement.
All right. Well, thanks for letting me speak.
You're welcome. Hi. Sure. This isn't public comment time.
That's what I'm curious
Yeah.
about.
This is just to see both sides. Yeah. You'll have an opportunity on public comment time to make a public comment on this. And then you can extend the rules. But right now, we need to either make there's a motion that was made, and you can speak at public comment time. Is that okay?
Is that not what this is?
No.
It's not.
No.
So even though I live out there, I don't get a chance to comment?
You will. You will.
During this meeting?
During this meeting.
Well, okay.
Justice Lemming.
I want to suspend the rules and let these two folks speak that was up there.
Second.
And 3 minutes apiece.
We have a motion and a second to suspend the rules and allow two people to continue to speak 3 minutes each, even though it's not public comment time. All in favor, raise your right hand and say aye. 1, 2, 3, 4, 5, 6, 7. Okay. Young lady, please come to the mic. Thank you.
Hi.
Hi.
My name is Shelley Cordine. My name is Shelley Cordine, and I'm here in support of the Stewart family Christmas lights. My family has 9 acres, about a half a mile west of the lights. We've lived on Wyman Road for about 17 years, so we've seen a lot of change and growth and transformation over the years. On March 16th, we received an anonymous note in our mailbox stating that the lights have caused our roads to be unsafe, polluted, and our neighborhood with unwanted sound, light, and trash, and to come to the meeting to have our voices heard. Unfortunately, it's usually only the people that complain that get heard, so I'm here to try to bring something positive to it. We have not personally experienced the negative impacts that people have brought up at this meeting or meetings in the past. The extra traffic has always been dealt with quickly and alleviated with only minimal backup on the busiest nights. We've never seen a standstill in both lanes of traffic that would impede any emergency vehicles. I believe an ambulance would be able to get to the lights if needed. I'd say the traffic is far less out there than it is visiting the square during popular times. You know, if you're going to do Christmas lights, you're going to do something like that, you live in that area, you're going to have traffic. We have not had any trash or any safety concerns of any kind. We do have some speeding on our road, but that is a year-round problem and completely unrelated to the lights display. Where we are, there's no extra noise. We have no noise at all, less than half a mile. The lights go off at a reasonable time and affect us in no way. They aren't any brighter than anything that we see from the football stadium during a special occasion, which we like to. Go Hogs. You know, it's just, we enjoy the lights. It brings a lot of joy to our region, and not to mention the tax revenue. We hope that it will be able to continue and operate, bringing a little extra Christmas spirit to the area.
Thank you.
Thanks.
Jason Tuck, 4246 Wyman Road. First of all, let me say, that's great. What you're doing, discussion, I think that's what it's all about. Getting more information, conditional use permitting, large-scale development permitting, floodplain permitting. All your questions are going to be answered because they have to have traffic studies, and that'd answer the widening the road and what they're going to do. That's great. And their counselor come up here, and I want to applaud him. He did a great job of outlining that. We're tickled to death. I don't care whether you're Stewart Camp or not Stewart Camp. I think that's what everybody was looking for. But I was listening closely for the answer to one question, and I never heard it. And that is, do you plan to open without the proper permitting? I'll be looking to get the answer to that as we move through this process, and I look forward to seeing you in a month, and I look forward to getting their progress on that. Thank you.
Thank you, sir. Come quickly. Quickly.
First off, I'm not a speaker.
Wait. You need to bring the mic.
I am not a public speaker or anything, but I live on Canvas Road off of Star Road, and we've lived there for 33 years, and I've heard people say that if we don't like the traffic, we should move. We moved out of the city limits to have a quiet place to live. The traffic might not bother her, but we cannot get to our house on Canvas Road. The traffic is backed up for 2 hours at a time. It's out of control. Traffic's nonstop coming down Star. We have to go all the way to 45 to come to our house, and it still takes forever to come down Star. It's not just Wyman Road. We've lived there 33 years. This is not right. I'm all about it. People being self-employed, we're self-employed, but they're impeding on everybody, miles away from that. It's out of control. Something needs to be done, and I appreciate him bringing it up. Thank you.
Thank you. With that, Justice Wilson?
Yes, I would like to reintroduce my motion that we postpone until the next county services meeting.
I have a motion by Justice Wilson to postpone until the next county services meeting, seconded by Justice Dean. I have some discussion. Justice Massengale.
Yeah, I don't think it's necessary to postpone this. If we send this to full court, we'll have 3 readings. We'll have plenty of opportunities to debate this.
No, not for resolution.
Not for resolution, it's just
No,
one?
it's just one.
Okay.
That's for appropriation.
Yeah, I also feel like this is kind of unusual, the process that we've gone through tonight. It feels like we're debating a CUP, and that's not what's at, that's not what we're here to debate. There's a lot of comments made. I had no opportunity to respond to any of them. But, you know, I think this ought to go to full court. I don't see the point in putting it off any longer.
I have Justice Pond. Butch Pond. 007. I'm sorry.
Yeah, it's,
I apologize.
thank you, Madam Chair. No problem. Hey, I understand how J.P. Massengale may feel the way he does, but I want to say I'm for the postponement, so this will be looked at some more, and we can see whether this cut process is moving right along within the next month. And I'm gonna say again, I appreciate this being brought to us, appreciate everything he's done on this, Madam Chair.
Yes.
Even though I will vote for the postponement. So it gives ourselves and the public more time to look at this and act on it. I think you might find out there's a whole lot more folks that wanna come and speak on this subject. Thank you.
Thank you. Justice Wilson?
Thank you, Chair. I appreciate this resolution tonight because it has helped shine a bright light on this issue, which is needed no matter what happens after this. But I continue to maintain that, I'm in favor of postponing because as it is, some things have been called into question. Maybe we could say we're quibbling over details, but I hate to vote for a resolution that is at least maybe partially inaccurate. I don't know if it is or not in certain parts, but just to give us some time for that. And also, I would hope that if we're going to have a CUP on this and that process starts, I hope that we're deep into that soon, because that's, as has already been mentioned, that's when the real debate will happen. So this resolution, if we postpone 1 month, this resolution is not going away, and it gives us some time to do things, I think, in a more appropriate manner, and that's why I brought that motion forward. Thank you.
Thank you. Are we ready to vote on the postponement? All in favor of postponing this resolution till the next month's county services meeting, indicate by raising your right hand and say aye. Aye. 1, 2, 3, 4, 6, 7, 8, 9. All oppose? 1, 2, 3, 4. The ayes have it. This motion has been, or this resolution has been postponed till next month's county services meeting. Moving on with the agenda, I have item number 10. I'd like for Justice Coger to go ahead and introduce that, if you would please, ma'am.
Thank you, Madam Chair.
1 moment, please. Thank you.
Thank you, Madam Chair. And I'm sorry that we're here this long, and please don't hold that against me or my ordinance that I'm about to introduce. I want to tell you that I had 2 pages of introduction. I've cut it down, okay?
Thank you.
I just want to touch on why I'm doing this. So to be honest, I did not know until a couple of weeks ago that resolutions did not have to come through committee, because every resolution I brought I've always done that, so I thought they had to. And so that's why I'm bringing this. But I know that on this court, we've always valued committee review and public input. And while resolutions are not legally binding, did someone read the ordinance? Forgot that. Did you read the ordinance?
I asked you to introduce it, read it. I'm just,
Oh, okay. Let me read the title.
okay.
An ordinance amending ordinance 2021-26 and for other matters pertaining thereto. So that's the ordinance that sets the rules for bringing items onto the agenda. And so we know about that. So what I'm doing now, I want to amend that ordinance so that it will include resolutions. And you've got the ordinance in front of you. It's on the screen. So while resolutions are not legally binding, they do represent the official position of this court, and our words matter. I think resolutions are very important because they reflect that at least the majority of the JPs feel a certain way. And this is where we stand on this issue, even though, again, it's not binding. If something is important enough to represent the position of this court, it's important enough to go through a transparent process. And requiring resolutions to go through the same process as ordinance ensures public input, proper review, and informed decision-making. So this ordinance, there's still some flexibility with it. As always, a 2/3 vote can add anything to the agenda, any agenda at the beginning of the meeting. And I'm not trying to limit anyone. I just want to make sure that we do our work in a transparent and accountable manner. I want us to think about setting a consistent process going forward so every JP and the public will know what to expect when it comes to resolutions from this court. Transparency should never depend on whether something is called an ordinance or a resolution. It's from this court, it's important. We need to have a set process to do that. But Madam Chair, before I make...
Article 7? Are you going to make it?
Madam Chair, before I make my motion to pass this on to the full court, I need to I have an amendment for my ordinance.
Okay.
And I want to say that I did commit infraction a while ago when I spoke for Attorney Lester, and I'm sorry I did that. But today, I sent this amendment that I'm about to read to you. I sent it to Attorney Lester, and he emailed me back and said, I think that will work.
That'll work.
So I do have that. And I'd like to make this amendment. This ordinance shall, it's Article 7, this ordinance shall not apply to those resolutions that honor individuals or entities, express appreciation, or authorize marriage officiants, period. That's the only amendment I have to make to my ordinance. Thank you.
And that's because that doesn't need to go through a committee to get permission to officiate the marriages and
Yes,
weddings.
I never wanted that.
Okay. So we need a motion to amend. She made the motion to amend. Gary Ricker
That's my motion to amend.
seconded. All in favor of allowing Article 7 to be added to this this ordinance? Say aye. Aye. I didn't allow for any discussion, did I? Was there any discussion on this? All opposed, say no. The yeas have it. Article 7 is included in the ordinance. And now will you make a motion?
Thank you, Madam Chair. So I would like to make a motion that we pass this ordinance and send it on to the full quorum court with a due pass resolution.
I have a motion by Justice Coger to pass this ordinance to the full quorum court with a due pass recommendation, and a second by Justice Lopez.
And Madam Chair, I'd like to, help me with this. I don't remember how, I want to try to move it on to its second and third reading. I don't.
No, you can't. You can't do that. You have to do that at court.
Oh, that's great.
This is just moving it on to the full quorum court with a due pass recommendation.
I'm sorry. That's my resolution. That's my motion then to pass it on.
I have a motion and a second. Is there any public comment? Is there any discussion? I thought we had a discussion. Is there any discussion? Yes, sir. All in favor? We've already asked for public comment, seeing that there was none. All in favor say, I asked for public comment. All in favor say aye. Aye. All opposed? Aye. We had one opposed, so this will be passed on to the quorum court.
Thank you.
Do we have any citizens' comments?
They already spoke.
Seeing that there is none, this meeting is adjourned.